All right, so I want to talk just about some basic things. Y'all feel free to interrupt. Raise your hands if you got a question. I like to do this very informally. You'll find out pretty fast that I'm going to know your names. We're going to do a lot of discussion. We'll do a lot of interaction in this class. I figure if I'm going to go through the trouble of coming over here and lecture, and y'all are going to go through the trouble of coming over here and listening, then we might as well have some back and forth in there and make it as interesting as possible. Try to keep you awake, try to keep everybody at least somewhat interested, and make the time go faster. I'm a little bit different than probably most of your professors in that one of the requirements for teaching this class is that I have to actually be a practicing attorney. So I am full-time at CSU, but I also have a side hustle of my own law practice. I have an office downtown. So what that means is that I'm just not here that much. I'm not on campus that much. And so if you need me, I'm available for you anytime. It's just going to be hard for you to drop by and find me. So I will be happy to make an appointment to meet you anytime, talk on the phone anytime, do a Zoom anytime. You just need to probably set that up with me ahead of time. I probably will have some office hours because I'm required to, but I doubt I'll be there. I'm on campus from 8 a.m. until 10:45 on Tuesdays and Thursdays. I have an 8 a.m. class before y'all, and then this class, and then that's really it. And so the best way to get a hold of me is to text me on my cell phone. You should have that already in the email and the announcement. I'm going to put it in the syllabus when I post that. But that is the easiest, fastest, best way to get in touch with me is just text me. I am not around my office phone much because I'm in court or meeting with folks or doing stuff, or I'm over here. So calling my office phone is a terrible way to get a hold of me. The best way is text. Second best way is to email me at my work email, not my CSU email. CSU email used to let me forward automatically my CSU stuff to my personal email, but now they quit that, which means I've got to log in and show my face and type in the number and all that however many times a day to get my CSU email, and that just, the day gets away from me and I'll end up going a day or two without checking it. So if you email me on my personal email, I'll get that on my phone immediately. Best way to get a hold of me is to do those things. We do have an attendance policy in this class. I will admit to you that I'm the type of professor that I hated to have. I like to sit in the back row and pull my hat down really low and work a crossword puzzle. Back when we used to have those, you could work them on paper actually in the school newspaper. Come on down to the first 5 rows if you don't mind. And so I am that guy who is going to require you to come to class and who's going to call on you and all that kind of thing. Kind of guy I hated. The reason I do it is that, again, if I'm going to come over here and do this, then you might as well participate too. But also, I know that you learn more when you come to class and you have to pay attention. That's a scientific fact. And so that's just kind of how it's set up. The way that I do that is you get 5 absences. You can use them however you want. I don't care. We don't worry about excused or unexcused. You don't have to tell me if you're not going to be here. If you're sick, you don't have to let me know that you were sick. There's no such thing as excused or unexcused. You just get 5. After you run out of those, that's it. I'll drop you from the class. Now, life does happen. People have babies. People get ill. People are hospitalized. Stuff happens. I'm not going to drop you if you get in a car wreck and you're hospitalized or whatever. You just need to be in touch with me and let me know. Okay, I'll work with you. What I don't want to do, because it's just, honestly, it's a waste of my time and yours, is I don't want to get to your 6th absence of the semester in March and you have to make up some BS about somebody dying or somebody being, I don't want to get into that. So you just use 5. You got 5, use them however you want. But after 5, that's it. Fair enough? Okay, you're nodding. You don't have to agree, but that's the way it's going to be. This class, I think you have a little bit of benefit in this class in that most students find that the stuff we talk about is somewhat interesting. It's topical. It's not dry. We're not talking about formulas and numbers all day and theory and that kind of stuff. So I hope that you'll at least, even if this is not your thing, you'll at least find it to be a class that was worth your time and that was interesting to you. We can't cover, business law itself is a huge topic. So our goal is not necessarily to learn the law. Our goal is for you to learn major areas of the law, basic principles in those areas, and be able to spot issues when they arise. Okay? Several reasons that this class is not about teaching you what the law is. Number one, there's not enough time. A first-year law student, for example, would spend an entire year studying criminal law, an entire year studying contract law. We're going to do contract law in a week, 2 class periods. We're going to do criminal law in a week, 2 class periods. So we're really hitting the highlights. Another reason that we're not learning exactly what the law is that it changes. This is not about memorizing what the law is, because it could change the day after we finish class. It will change. That's the nature of the laws. Pretty much you can bet that it will change in some form or fashion. Another reason we're not memorizing the law is it changes between jurisdictions. So Georgia contract law or Georgia criminal law might have a lot in common with Alabama criminal law, but it's going to be different. It's going to be different than Louisiana law. It's going to be different than South Carolina law. So we're not going to spend time memorizing those things. Instead, I want you to finish the class and in your career and in your day-to-day lives and jobs be able to say, that's a contract law issue. I need to check on this. I need to be worried about whether or not this needs to be in writing. Certain kind of contracts have to be in writing. I don't necessarily need you to memorize which ones have to. I just want you to remember that some of them do. So that when it arises, you can then go and figure out for yourself, is this the type of contract that needs to be in writing? Is this a criminal law issue? Is this an employment law issue? This employee just came to me and was talking about some difficulty that they're having standing for long periods of time. What does that mean? Do I have any duties with that? Does that bring up any Americans with Disabilities Act issues? Does that bring up any accommodation issues? Do I need to go talk to HR about this? I want you to recognize sort of some of the broader issues that there are and to spot those, and then we're going to learn sort of the critical thinking skills that you would need to sort of work through a problem, a legal problem, big picture stuff. I do not have a textbook, or don't require a textbook. I want to talk a little bit about that. My experience is that students hate textbooks, that textbooks have a lot of extra information in them, and that even if I did have a textbook, and even if it had nothing but good information, most students still don't read. So, I've decided to try to make a compromise with you guys on that, in that there is none. There's no textbook. I'm going to give you what I think you need to read. And the trade-off is, I hope that you'll read what I assign in exchange for not having to read a whole bunch of stuff that you don't understand or is superfluous or that whatever. I'm not trying to trick anybody. I know what I want you to learn. I'm going to give it to you, and I'm going to test you on what I give you. We're not trying to do any busy work, and we're not trying to do any extra stuff in here. So, my screen just went off. Is anybody new to Cougar View or the way that courses are set up online at CSU? Okay. So everybody knows how to log on and find the I think it'll come up in a minute. All right, here we go. Everybody knows what this looks like. This will be our course home. Well, this is for section 1, but all of mine are the same, but I'll pull up to. All right, go to content. There's going to be a content for every unit that we do. They'll be numbered sequentially. This is our content module for Unit 1. Introduction, sources of law, and the court system. We'll go through that in a second. The way that I've set the course up is we're going to be on a week-to-week basis. We're going to take a different topic every week. I will lecture on Tuesdays. We'll have discussion on Thursdays. You'll have a quiz that's due the next Monday. Pretty much every week. Some of our stuff will take 2 weeks, but nothing takes longer than that. That way you have predictability. You know that pretty much every week I'm going to have an assignment or a quiz due for business law. They're not long. Some of them are 10 questions. I think the longest one is maybe 30 questions or something like that, but they're mostly somewhere in that area. I'm quizzing you once a week on the stuff that we covered the week before, and then we're done with it. So we don't have big exams. We don't have midterms. Once we test that for the week, then we move on to a different subject. Okay? Your final is cumulative. That's only because it's required. The school requires me to do it. We can't get accredited. This class can't be accredited if it doesn't have a cumulative exam. Don't worry about that right now. When we get to the end of the semester, I'm going to tell you what's on the exam. I'll give you a study guide. Most people do really well on my exam. I don't want you to worry about that. I'm designing it to where I want to test you while it's fresh on your mind and while we've learned it, and then we'll move on to the next thing. There's also not a lot of overlap. It's not like we're building for 4 weeks on a certain accounting problem or something. I mean, we talk about sources of law this week, and we're going to talk about something different next week. So there's no need to drag that out for you. I'm going to record my lecture onto a YouTube video. So if you miss class, it's easy to watch and make up. I do that mainly for my online class so that they can do the same thing that we're doing. But also, in case you have to miss class, you can just watch the lecture video and make it up without worrying about what you missed. I don't do, so pretty much every Monday you'll have whatever's due for that week will be due. I have had students in the past say, because I know some folks are just wired like this, I really wish there was a schedule, Professor. I'd like to know what the schedule is. We're just kind of we're on a week-to-week basis around here. You're going to have something due pretty much every Monday. You can count on that. But I may have to move stuff around. I may have a court appearance and have to be out. I'll probably end up missing 2 to 3 classes this semester for one reason or another, and we just need to be flexible on it. So for those of you who like a set-in-stone schedule, I apologize ahead of time. I'm going to tell you up front that stuff's due Monday night, and if you don't do it Monday night, don't come to me on Tuesday or afterwards and give me some reason why you couldn't get it done Monday night. That's a waste of your time and a waste of my time for me to have to figure out who's got real reasons and who doesn't. Most of the time it's not real reasons. Somebody will say, I left my phone in a bar Saturday night and then they were closed Sunday and Monday, couldn't get in Cougar View. I'm not getting into that. You know it's due Monday night, do it Monday night. Now, if you know ahead of time that you've got something going on, like a lot of folks have kids, a lot of folks have jobs, even those of you who don't have families or jobs have lives, and I understand that there's other stuff going on. Folks are in athletics, that you have games and travel and stuff like that. I'll work with you on due dates for anything like that, you just got to let me know ahead of time. I don't like after the fact. Ahead of time, I'm all about accommodating your schedule if you need extra time. Also know that, stuff happens. If you get in an automobile accident on a Monday afternoon and you're in the hospital, let me know. I'll work with you. What I'm trying to avoid, though, is just the don't text me on Tuesday with some reason why you couldn't get it done the night before that isn't legit. All right. We do have, I'm going to put a discussion post up pretty much every week that'll track our units. Y'all should be familiar with discussions if everybody's been at CSU before. They're not supposed to be busy work. I try to make them where you'll get something out of it. The feedback I get is that folks think it's worth it. The way I grade it is that at the end of the semester, I'm going to go back and look and see who all answered all the discussion questions. If you answered all the discussion questions, you get 100 for your discussions. That's an easy 100. If you answered 8 out of 10, you'll get an 80, so on and so forth. I do read every week what you write, but I'm just not grading it until the end. So you kind of got, that's the one thing that you have some extra time to do. Again, no busy work. I'm not going to assign you a discussion question that I won't take the time to read what you write the answer to. I'm not grading, I'm going to grade to make sure you did it, but I'm not grading it to see whether I agree with it or not, or, if it looks like you pasted something from the internet or it's chat GPT BS, or if you just did 2 sentences, then I'm not going to give you credit for that. But if you genuinely made an attempt to answer it, I'll give you credit for that. I meant to say this earlier. All of your quizzes in here and assignments and your final exam, everything is take home. We don't do any testing in class. Not wasting any time in class on that. So you can do it, it's all on your computer, it's all open note, it's all open material. Anything that I assign to you, you can use. If we read a case, like we're going to read a case for Thursday, and the case is on the quiz Monday, you can look at the case. If you need to review and look in it to find the answer, that's fine. You can use your notes, not a problem. Just no outside sources. No Googling or AI or anything like that. I'll also tell you that, these days, I've thought long and hard about, so there's 2 sides to AI. Y'all are going to use AI in your careers, in your lives. We need to learn how to use it well. We don't need to be afraid of it. We need to embrace it. We need to be teaching y'all how to use it smartly. But using it to answer questions on the test is not using it smartly. I don't know the sweet spot in that. I think we're like at such a beginning, such at the edge of the frontier on all that. I don't know. I may be too old to figure it all out. That may be something y'all get to deal with. I'm not going to spend all my energy and time trying to figure out how to make my class AI proof. I don't think that's wise. I'd like to be cheat proof, but I don't know that we need to be AI proof. So I write my own questions, and it's specific to the stuff we talk about in class and that I assign. So really, the feedback I get is it doesn't really lend itself to AI cheating type stuff as well, but that's sort of all I have to say on that. Participation, there isn't like a separate participation grade, but man, I don't have any problem bumping somebody up a letter grade if they've come to class and looked me in the eye and participated and followed along and been engaged in what we're doing. I got no problem bumping people up who are borderline on all that. Same thing as the other way. I mean, you might have an 88, you might have a 78 or 68, but if you've come to class and done like me and done the crossword puzzle and pulled your hat down low and not participated, I'm not bumping anybody up who does that. So it does matter. I'm going to hopefully make it easy on you to participate because I'm going to be calling on you and asking you anyway. I'll know who you are pretty soon. So it's a little bit hard to hide. But I do think participation matters and it counts, and you'll get a lot more out of the class if you do. So every topic that we take up, when I lecture on Tuesdays, I'm always going to post the lecture outline to the content module for you to pull up. And that's so that you can follow along, so you can sort of see where we're headed. You see what we're covering. But it also helps you from not having to worry that you got to write down everything. I do think that taking notes is very important. There's stuff you need to write down that's in addition to just what's in this outline. But I think the class will make more sense to you if you take notes using the outline that's provided. There may be some stuff in that, or there will be some stuff in the outline that I can't get to in class, can't get to all of it, that is fair game for you to be quizzed on. So it is important for you to read the lecture outline every week. They're not all that long. Again, I take these lecture out, this is my outline, but I based it on an outline from the textbook. So instead of a chapter that's 60 pages long, we got an outline that's 8 or 10 pages long. And I'm hopefully going to fill in the details that I want you to know through the lecture. All right, that's how we're set up. Anybody have any questions on how it works? All right. So pull up your, before I do that, every week you'll have a content module. It'll be a unit number. It'll tell you the topic, the subject name. It'll give you a beginning date. At the beginning of the content module, I'm going to show you everything that you need for that week. This required reading, that's all posted down here. It'll all be found right here. If you have a quiz that week, it'll tell you when it's due and what it's over. It's going to be over the lecture and the reading. Quizzes are posted on Thursdays after class. So you have from Thursday at noon, roughly, until Monday night at midnight. Your discussion question, if there is one, it'll tell you in this section. The lecture video links to YouTube are going to be found right here. So I'll post today's lecture on here when I get back to my office. And then the quiz, the reading, everything will be down here. Should all be in a one-stop place. Anybody needs to know what's expected of them that week or what's due that week is all in the content module. All right, so let's jump into then our topic for this week, which is sources of law and the court system. Today I want to cover basically the sources of law. This is a review for you from your high school civics class and maybe some other places, but this is stuff that shouldn't be all that new to you. I'm going to talk about 4 classes of different sources of law, one by one. Constitutional law, statutory law, administrative law, and case law. All right, just a foundational review here real quick. Our country is set up and founded. We have a federal system of government, and we have state governments. Federal system, again, applies to everybody in the country. That's the president, the executive branch, the Supreme Court and the federal court system, Congress, the United States Senate, the United States House of Representatives make up Congress, and then administrative agencies at the federal level. That's our federal government. Every state will have its own constitution, its own legislative body. State of Georgia has a legislature, state of Alabama has a legislature, so on and so forth. Every state will have their own administrative agencies. State of Georgia has a Department of Natural Resources. It set hunting regulations. State of Georgia has a Department of Revenue that handles tax collection, spending. On the federal level, those would be like the Environmental Protection Agency, the United States Treasury, the Internal Revenue Service, the U.S. Treasury, those type of things. We're going to get into a little more detail. But just again, painting the picture. We've got the federal overarching system of government, and then we got 50 sets of state governments. Constitutional law as a source comes from constitutions. At the federal level, we have the U.S. Constitution. At the state level, each state has their own constitution. They're the highest source of law that we have, meaning that no other laws can conflict with the Constitution. The U.S. Constitution is higher than state constitutions. So the state of Georgia can have a constitution that says whatever it wants, so long as it doesn't conflict with the U.S. Constitution. They have to be consistent. Now, one of the biggest changes and evolution in the balance of power in our government over time has been the role of the state governments and the role of the federal government. When the Constitution was drafted, 1700s, the founding fathers envisioned that we would have a federal government that was extremely limited. It would handle things like the mail, post office. It would handle things like the Army. Things that make sense to be coordinated at a federal level. Okay? The U.S. Constitution spells out specifically what the federal government can and can't do. And it says that everything else is left to the states. And at that time, that everything else was a lot more than what was reserved for the federal government. Now, balance has flipped over time just because of the nature of society and our lives and technology and all those things. Consider for a second, when the Constitution was written, it gave Congress, gave the federal government the power to regulate commerce, business, trade between the states. That makes sense. If we've got all these individual states, it would make sense that we want to let the federal government oversee the trade between them so that we have some sort of uniform policy for that. We don't have 13 states or however many at each time doing 13 different ways. We're going to regulate commerce between the states. There was almost no such thing as commerce between the states in the 1700s. Think about it. We didn't have distribution networks of highways, of railroads, of airplanes. We didn't have tractor trailers. We didn't produce goods. We didn't have manufacturing. We grew watermelons. We sold our watermelons locally. We didn't grow watermelons, pick them, and immediately put them on a tractor trailer bound for California. Interstate commerce just wasn't much of a thing. So when that was reserved for the federal government, that was a pretty limited role for the federal government to have. Fast forward to today, it's hard to think of any commerce that isn't interstate. I grow watermelons, pretty much going to find their way out of the state of Georgia. We live on the state line. They're going to make it to Alabama for sure. So interstate commerce went from being something that really almost was non-existent to something that is omnipresent. Interstate commerce is pretty much, it's hard to think of any business that isn't. The internet really put the final nail in the coffin of commerce that was not interstate in nature. My business could be interstate in nature, and I never leave my home. My business is my laptop, and I do it from my sofa. But if I conduct business across state lines over the internet, that's interstate commerce. So it's really all encompassing. So in that way, the federal government has become more involved, depending on your perspective, over involved. However it is, that's how it's evolved. The U.S. Constitution gave the federal government the power to regulate interstate commerce. That's found in the Commerce Clause of the U.S. Constitution. That's kind of how it mushroomed from overseeing the post office and the Army to everything that it does today. All right, so back to constitutional law for a second. Found in U.S. Constitution and state constitutions. The next category I want to talk about is statutory law. A statute is a law passed by a legislative body. On the federal level, that's Congress. They pass statutes. The laws that they pass are called statutes. At the state level, the state legislatures pass laws that are state statutes. Some examples would be the Americans with Disabilities Act. You've probably heard of that. That is the law that talks about not discriminating in employment on the basis of disability. It's the law that talks about making public places accessible for those with disabilities. That's a federal statute, the Americans with Disabilities Act. Statutes are grouped by subject, and then they're published in volumes of books, although no one cracks the books anymore because it's all online, right? But it used to be that when I was in law school, if I wanted to go look up a Georgia criminal statute, I'd have to go up to the bookshelf and I would pull the volume that is composed of Georgia criminal statutes, and I'd flip through the book to find the one I was looking for. I'm going to bring a volume on Thursday just for you to pass around and you can see. I mean, they still exist. They're still compiled by subject and they're still published, but they're just also published online in ways that are a lot easier to access and research. Now you can do a keyword search in the search engine and it'll come up with, it's just a lot easier to find the law you're looking for. That's statutory law. Okay. Administrative law is another area I want you to be familiar with. Administrative law is made up of rules that are put forth by administrative agencies. That sounds pretty basic. Here's an example of that. Federal agencies and state agencies abound. On the federal level, we have the Environmental Protection Agency, we have the Internal Revenue Service, we have the Occupational Safety and Health Administration, we have the Federal Trade Administration, Federal Trade Administration, the Federal Communications. I mean, I'm getting tongue-tied because there's so many. All right, and they are executive agencies. Their job is to carry out the law, enforce, administer the law in their area. So here's how an administrative law relates to statutory law. Let's say that Congress passes a statute called, this is an actual statute, called the Clean Air Act. And it says that businesses, individuals cannot pollute the air. Say I have a manufacturing plant and Congress passes the Clean Air Act. I can't pollute the air with the output emissions from my factory. What it doesn't show in the Clean Air Act is the parts per million of carbon dioxide or lead or carcinogens, or now I'm getting into things that I don't understand. You won't find that in the statute. Congress just passed a law that says you can't pollute the air. So how are we going to flesh that out and know exactly what is pollution and what violates that law? Well, the Environmental Protection Agency is tasked with implementing and carrying out that statute, enforcing it, and they make up rules to flesh it out. So the Environmental Protection Agency will come up with rules that say your emissions cannot have more than 5 parts per million carbon. I'm making this up, or whatever it is. That's where we find that out. Administrative law is just as binding on us as statutory law and constitutional law. It's just where a lot of the details are. Now, administrative law is binding on us, right? But it's not passed by anybody that we elected. It's not passed by a vote, anybody's vote or approval of state legislatures or anything like that. Not found in the Constitution. It's made by rules, and it's made up by the people who are in those agencies, ostensibly who are the most qualified to figure that out. Let's say that the United States Senate's passing the Clean Air Act, and they can all agree amongst the 50 senators that we need clean air, and we don't want factories to pollute. But if you ask Senator Jones from the great state of Connecticut, what should be the level of carbon dioxide that factories should be allowed to emit into the atmosphere? No senator's going to know that. None of us are going to know that. People who are going to know that are environmental engineers and people who are experts in that area. Those are the folks who are supposed to be making up rules at an administrative level. Now, they don't have the ability to just go make up rules with no rhyme or reason. They still have to be constitutional. They still can't be contrary to any statute. They're still held to those standards, but they're making those rules. And that's a huge, huge area of the law, administrative law. All right, let's talk about case law for a second. So, quick history lesson, not testing you on this, but our system of law is based on the English common law system. So if you go back centuries, before anybody even thought of this country, back to merry old England, that was a time when we didn't have widespread publishing, right? We weren't able to distribute and disseminate written volumes of the law to everybody. It was kind of left up to the judge on a case-by-case basis. And the disputes were mostly personal in nature. We didn't have big corporations. We didn't have giant class action lawsuits. It was mostly like, Moss stole my goat. And I need, Judge, I need my goat back, or I need him to be punished or something like that. Okay? And we go in front of the judge, and the judge decides that Moss stole my goat, and he puts Moss in jail for 6 months. All right? Next day, Dowdell steals my goat. We go to court on him. The judge finds that he stole my goat too. The judge says, well, I gave Moss 6 months on the goat theft, so I got to give you something around the same thing. Next time somebody steals a goat, the punishment for goat stealing is 6 months. It just builds up over time. They weren't going from a top down, like a Congress or a king passing laws that then the judges were interpreting. They were going bottom up. They were taking the disputes that they found before them, making decisions based on the facts that they found before them, and then they would take future cases and treat them in the same way or consistent with the way they treated past cases. That's the English common law system. They didn't have a Congress that said it's illegal to steal somebody's goat, but they had a court system that would enforce penalties against goat stealing. Now, we adopted that when we started our legal system in this country. We've modified it because we have constitutions, we have statutes, we have administrative law, but we still have a flavor of the English common law in that we still have to have courts interpret the law. We can have a general constitutional principle called freedom of speech, right? The Constitution says we're guaranteed freedom of speech, but doesn't go into any more detail than that. We could have a statute that talks about freedom of speech. We could have administrative agency rules, but we still could have a dispute. Here's a real life example of that. The Constitution says you're guaranteed the right to freedom of speech. States passed laws that said you can't burn the flag. Statutes, criminal statutes passed by the legislative bodies, you cannot burn the flag. Somebody burns a flag, they get arrested, charged with the crime because they violated a state statute. That person goes to court and says, that state statute is unconstitutional. It violates the Constitution because flag burning is speech. And I'm guaranteed the right to have free speech by the U.S. Constitution. Well, we're not going to settle that by looking at the Constitution. The Constitution just says you're guaranteed the right to freedom of speech. We're not going to settle that by looking at the statute. The statute says it's illegal to burn a flag. We've got to have the court system settle that by interpreting the words in the Constitution to see if that covers flag burning. So the court system is the ultimate determination of whether or not a law is constitutional. And as courts make those decisions, they put them in writing and they become binding precedent as case law. So that if the United States Supreme Court says people have the right to burn flags as free speech, then the state of Hawaii can't turn around the next day and pass a law that makes it criminal to burn flags. We have case law from a court that says the Constitution protects flag burning. So that is a way that the courts have the ultimate decision in fleshing out and interpreting the words in the law. Kind of how it all fits together. Case law, written decisions from courts, just like back in England in the goat theft. Those decisions got built up over time. We've got an enormous body of case law that's built up over time. Here is an example of how that would work also. Let's say that Congress did pass the Civil Rights Act of 1964, which is the landmark law that made it illegal to discriminate in employment on the basis of race, color, religion, national origin. But that's all it says. That statute says it shall be illegal to discriminate in employment on the basis of those categories. That's all it says. It doesn't go into defining how far that goes. Let's say that I am an American citizen. I was born in America, but my parents are Egyptian. I think that I got fired from my job because my boss is prejudiced against Egyptians. So I sue my employer for violating the Civil Rights Act of 1964. And my employer says, we didn't violate that act. He's American. He was born here. He's a U.S. citizen. I say, no, national origin could mean my ancestry. The judge is going to look at the statute and the words and say that it just says it's illegal to discriminate on the basis of national origin. The court's going to have to decide whether or not what national origin means. Does that include American-born citizens whose parents who have ancestry from other countries? So let's say that the judge in my case says, yeah, national origin includes not just where you were born, but where your parents were born. So going forward, that's binding case law precedent. The next time somebody gets fired and they think it's because of their national origin, even though they're American citizens, their parents were born somewhere else, that law will cover that. It's not a defense for the employer to go to court and say, well, they're American citizens, they were born here. But what about the employee who is fired, who thinks they're fired for being Egyptian or on the basis of national origin, and they were born, the employee was born in America, the employee's parents were born in America, but the employee's grandparents were from Egypt. We have precedent that says that law is interpreted as covering your parents. But we don't have anywhere that says grandparents. So I sue, or that person sues, we go to court, the judge has got to decide. Does the Civil Rights Act of 1964, do we read that to include national origin to mean your grandparents' ancestry? My argument as the employee is, Judge, there's no different. I'm 100% genetically Egyptian. Okay? Why should it matter if my parents were born here, but my grandparents? Why are we going to draw a line there? That doesn't make any sense. You've already found that if my parents were born in another country, that makes me eligible for discrimination. That's not a great phrase. That protects me from being discriminated. My grandparents should too. What would your employers, if you were the employer, what argument could you make? Not that people shouldn't be discriminated against, but what's an argument the employer might make? Where do we draw the line, Judge? Everybody in this country, unless you're pure Native American, is from somewhere else. Everybody has origin from somewhere else. Does that make every single American citizen protected from national origin discrimination? Really? I don't even know. I look at so-and-so, I have no idea what their national origin is. How could I possibly be discriminated against their national origin? Their family's been here for 10 generations. So the courts have to kind of sort that out. And they do, on a case-by-case basis. But the decisions they make then become binding for the future, so we build off of that. It's not a case-by-case basis where they can do one thing here and one thing here. One thing today and a contrary decision tomorrow. It's got to build off of itself. Now, the only wrench I want to throw into that is that the courts do over time sometimes not follow precedent. If you're like, well, you just told me we had to follow precedent, now you're saying we don't follow precedent. What's the deal? Courts are bound to follow it unless they come up with, there's no test for it, but they've got to articulate a reason why that should no longer be the law. Here's an example. In I think it's the 1960s, but y'all fact check me if I'm wrong. The Supreme Court of the United States decided that the U.S. Constitution protected a female's right to have an abortion. The U.S. Supreme Court decided that that was a protection that was enshrined in the Constitution. That's the law of the land. After that, a state couldn't pass a law that limited or restricted a female's right to have an abortion because we had precedent where the courts had previously interpreted the Constitution as protecting that right. Along came the Dobbs case a couple years ago, and the Supreme Court said, you know what? We're changing that. We're overturning precedent. That's no longer the law anymore. Another example is the case that you are assigned to read for Thursday, Brown versus Board of Education. Up until the 1950s, courts had consistently held that it was constitutional for public services and institutions to be separate for the race, for different races, as long as they were equal. That's what the court said. That did not violate the Constitution up until the 1950s. A group of African American students sued the Board of Education in Kansas, saying that's unconstitutional. The courts that first heard it said, we're bound by the precedent. We've got years and years and years of cases saying that separate but equal does not violate the Constitution. It gets appealed all the way to the U.S. Supreme Court, and in the 1950s, the U.S. Supreme Court finally says, you know what? We're going to rule that that's not constitutional. Here's our reasoning. The Constitution hasn't changed one word since it was passed. We don't change the wording of it. We change sometimes the interpretation of it. We don't change the words. In the 50s, the U.S. Supreme Court said, separate but equal is not constitutional. We're no longer going to follow that precedent anymore. So it does change over time. It doesn't just change with the wind. It doesn't change on a whim. It very rarely changes. It evolves some, they'll tweak it here and there. And over time, case law does change some. But it's, on the whole, case law is predictable and binding and guiding law for us. So that's kind of how all that works together. You have constitutional law, you've got states and federal government that pass statutes, you've got administrative agencies at the state and federal level that make rules to flesh out the statutes. And then you have courts that make decisions interpreting the laws, that they write written opinions that become case law. All of it works together. So that's kind of a review of how we got where we are. We will, throughout the semester, talk a lot about each of those kinds of law. So a lot of what we talk about the first 2 weeks is foundational to what we talk about for the rest of the semester. What kind of law does your dad do mostly? That's right, he's some litigation and civil litigation, that's what I thought. Does he do any criminal law? Okay. Well, good. Well, tell him I'm going to be calling him about coming to speak. And for him to be thinking of some good stories.
He don't be answering his phone.
He what?
He doesn't answer his phone.
He doesn't answer his phone. Well, then I'm going to go through you then. He'll be like me. I have to text him. I think I've met your dad before, but it's been a long time. He might not remember who I am, but tell him that I would appreciate. I'd love to invite him to come if he wants to.
Yes,
That'd be good. So, anybody have any questions? All right, for Thursday, I've got a little bit more of the outline to cover, and then we're going to talk about the Brown versus Board of Education case. So read it. I'll be asking you about it. I'm not asking you for legal conclusions and technical things. I'm asking you more things like, who were the people that sued? Who got sued? What happened at the first court? What were some of the reasons that the court gave as to why they weren't going to follow precedent? How are they rationalizing not following the law or changing the law? Big picture things. And if you don't know the answers to them, that's fine too. Just want you to read it and be familiar with it. The other stuff that I've posted for Thursday is mostly charts and examples, and I'm going to hit the highlights on those Thursday. But what you really need to read is the lecture outline and the case. All right, I will see y'all Thursday morning. If you can't